Good evening, everybody. I'm Tarhaka, Monterey Bay, and I'm going to be doing a series of videos. And my reason for doing that is because I've gotten a few calls from folks. They were needing to know this, that, and the other about the private versus the public, discharging of debt, doing up the declaration of trust, and needing to know the nationality and what part that plays in that. And so I decided to do this video so we can break this stuff down and give you some information and some things that you can work on and get more clarity for yourself. I've already done a video on setting up the irrevocable common law trust. It's the only type of trust that we use, the only type of trust that I recommend. And but I want to draw a little bit more significance on your nationality, operating in the private, the power of your declaration of trust, the duties of the parties involved in your trust, defining the language of a trust. Now, this is very, very important when you are doing any type of document at all, and you run into a word that you don't understand. You need to stop and look it up. Look up the word. You may not have this dictionary, and this is not necessarily the dictionary that you got to use, but you need to define the word. Not only that, let's take a look at the etymology behind the words that we are using. And by doing that, you become much more thoroughly furnished and accomplishing what it is that you're trying to accomplish. Okay? Defining the word, looking up the etymology of the words so that you will clearly understand what it is that you're dealing with. I mean, you will actually know. But if you just look over words and say, well, look, that sounds like it ought to be there, and they understand what I mean and all that, that's not good enough. Because if you have a question about a statement and you haven't looked up the word, you got the document, and then you don't know what it means. Come on, man. Let's get the let's bet out on this thing. Let's get your paper and pencil handy. Because we're going to be bringing out Queen Valahara Bay. She's going to drop some heavy information. I know a lot of you have already heard her do these lectures, but this is very important for us to understand when it comes to nationality, the United States of America, private and public. This is very, very important information. And I'm quite proud of the sister, and I decided to add her information in so that you will become thoroughly furnished in what you're doing in this country and understanding how serious it is for us to get this stuff understood. The benefits of your corporation. Everybody's on the same page. Now, when we're not talking about setting up a corporation. We're talking about setting up a private trust and living in the private. Not just operating in the private, but living in the private. That's a whole different ball game. Discharging your debt according to the law. Now, we're going to come back in the second part of this video, and I'm going to bring out some information. Of course, all this information is right there with our secure party and credit information right over there at New Debt Elimination. However, newdebtelimination.com. However, we want to briefly touch on some stuff here today to get you guys started. Identifying the people involved in your trust. What is the astrological information of these people? What do the vowels mean in their name? What does the science of astrology have to say about this individual so that you won't waste time dealing with people that's not going to make your trust successful? This is some very important information. If you go to tarhakadebtelimination.org, I gave you a breakdown on that, and a little video is sitting right there for you to look at. Opting out of the public and living in the private. We won't understand that. The mastery of contracts. We won't understand that. And the people that you're going to deal with, you're going to have to answer some questions that's in the back of these people's mind. Number one, if you're approaching someone about being a part of a private irrevocable trust, then they want to know, well, how can I profit? You know, what can I profit? When can I profit? Why can I profit? Where can I profit? Who says I can profit? And you want to answer these questions for them through benefits to be gained or losses to be avoided. Okay? I want you to listen to what I have to say about the importance of this trust. There's some very, very important information, and I decided to bring it back out here today and read this little part for you so you understand the benefits of getting your children involved in this thing. They are the beneficiaries, which is true. It says education of the heirs. Through involvement in trust management, the children as heirs to the family fortune become properly educated to prepare for their new roles in the trust. Now they are beneficiaries and have stake in the success. Showing them how to create a deposit slip, pay the bills, or have them included in the Board of Trustees meetings can work wonders. As this happens, you will likely see a surge in their respect for themselves and others, their willingness to pull their weight with chores and other duties to complete their schoolwork and ask for more. Being included contributes to their maturity, becoming worthy beneficiaries and potential trust officers. How about that? Isn't that wonderful? Now, I just wanted to touch on that, and I'm going to come back and we're going to be dealing some more out of these 6 books here. You know, of course, I've already told you this from the previous video. This right here, this will do a tremendous amount of good for you by getting these 2 books here. The Art of Passing the Book 1 and the Art of Passing the Book 2, Volume 1 and Volume 2. Okay? All right. Now, we're going to be coming back, but I want to go back and touch on the identity of people involved in your trust. Astrology is a science. Numerology is a science. And that information is readily available for you on the internet. If you want to go out and purchase the books, you can do that too. However, it's readily available. And I think it's worth your while to get involved in that, especially when you're talking about operating in the private. You're talking about moving massive amounts of money through a private trust, and you got people involved. It's important for you to know who you're dealing with. Who are these people? What do they make up? If it's your children that's involved, if it's your brother, your uncle, your sister, brother, it doesn't matter who it is that's involved. It's important for you to know them. And when you get these sciences and stuff, and you master the art of using these sciences, it make it much more easier for you to deal with this thing. Now, back up to the power of the Declaration of Trust. In your Declaration of Trust, that's where you lay it all out. You got everything in there. You got your trust certificates. You got everybody's duties, what is expected of everybody. Everybody understands their duties, what they're supposed to be doing. If you're trustees, what are trustees supposed to do? If it's the trust secretary, what's their duties? If it's a trust protector, a trust manager, what are their duties? What are their duties? So all of this is spelled out in your Declaration of Trust. Now, in my opinion, when putting the Declaration of Trust together, you will work much more successfully if you have people that are going to be involved in this thing, so you can get more creative ideas to add into the trust. If someone is passed hospital bills or whatever comes up, all of this information is covered in the trust. Who's going to replace who in the event of a situation? All of this is laid out. Your trust should be no less than 30 pages. But these are some of the things that I wanted to touch on with you involving operating in the private through a private trust. Now, your nationality, that's very important. Queen Valahara Bay is going to touch on that and show you what it is that the Moors got and what's going on with that. But what I want to add is being able to function, instead of functioning as an individual, and everybody's separated, let's start getting things together, get your house in order, and start functioning in the private, disconnecting from this failing system, and go ahead and use what's available to you and do it in the private. Okay? Now I'm going to go ahead on and bring her in, and after she's done, then I'll come back, and at the end, then we're going to get some more information. I'll explain that to you on the tail end of things before we close this video out. And keep in mind, this is a series when we're coming back dealing with other things, discharging debt, learning the difference between House Joint Resolution 192 and public law, and all of this stuff we're going to deal with. But y'all hold on a minute.
And that in fact this is our land. So beginning with that premise, whether you're more or not more, I'm going to start with what law really is. Most of us think that we go into a courtroom and understand the difference between a court and a courtroom, that the people who purport to use law really use words of art to make you believe in fact that law is on the table when you walk into a courthouse or a courtroom, when in fact that's not true. And I would like to share with you tonight, regardless of your religious persuasion, what law really is. Law, all law, is A-L-L space L-A-W, all law, all law. So for anyone who's of a Christian persuasion, don't be misled, and when you hear the term all law is God, all right? That is also what we would say in lawful terms a misnomer. Allah is not God. God has no capacity and no standing to all law. Because God means governmental ordinance departments. There is no comparison. Now, who can use law? Law can only be used by people who are in their sovereign capacity. And as I will share with you tonight, the majority of the people in the world, and I'm not going to get into all of the details about that, but the majority of the people in the world, 99% of them live in slavery today. So in 1863, via the Emancipation Proclamation, and I challenge you to go look in a law dictionary and look up the definition of emancipation and proclamation, and you will see that a proclamation is not a law. A proclamation is a public announcement by elected officials. It is not a law. So the Emancipation Proclamation of 1863 did not set any slaves free. What it did was standardized slavery, the United States being the model for the standardization of slavery, that all of the other nations around the world, as they reduced their people from their sovereign capacity and forced them to join nation states, then they were able to issue statute, codes, ordinances, resolutions on them. And a statute, as in a state statute of the Commonwealth of Pennsylvania, is not a law. It is corporate policy of the corporation that calls itself the Commonwealth of Pennsylvania Incorporated. All right? Now, a code is not a law. The United States codes, the code of the laws of the United States of America that are used in federal court and the Supreme Court, are not law. They are what they say they are. They are codes, ordinances, and resolutions of a municipality of the city of Philadelphia, which is a private nonprofit corporation that calls itself the City of Philadelphia. An ordinance and a resolution, as in parking ordinances, they are not law. They are what they say they are. They are ordinances and they are resolutions. All right? And the reason they are not law is because the only people who can issue law are people who are acting in their sovereign capacity. And the people who sit in these seats as elected officials are not, in fact, in their sovereign capacity. They are in a corporate ward status, meaning that they are wards of the state. They are members of the corporation, which is a nonprofit that calls itself the Commonwealth of Pennsylvania. And as long as they have a birth certificate on record with the Commonwealth of Pennsylvania, with that birth certificate being a contract, a birth certificate is a contract, and as long as you have a contract with the Commonwealth of Pennsylvania Incorporated, you belong to them, and that's what slavery really is. All right? So who can use law? If you are a member of a corporate ward state, if you are a member of a corporate ward nation that calls itself the United States of America, you are a citizen. Look in the law dictionary and look up the definition of citizen. A citizen is not a sovereign. A resident is not a sovereign. Therefore, if you use an address, which is a fictitious number associated with a designation issued by a corporate ward, right? Then you become under the jurisdiction of those people who are also corporate wards, but who are also slaveholders. All right? So if you are operating in that capacity, law does not apply to you. If you are a resident of the city of Philadelphia, which is a private nonprofit corporation, and you say you are a resident of the city of Philadelphia, then the ordinances and the resolutions of that private nonprofit corporation apply to you. If you are a citizen of the Commonwealth of Pennsylvania Incorporated, which is a private nonprofit corporation, then the statutes of that nonprofit corporation apply to you. If you are a citizen of the United States of America, which is a private nonprofit corporation, then the code of the laws, right, apply to you. But if you are a sovereign of the Moorish Empire, those ordinances, those resolutions, those codes, those statutes do not apply to you because you are not a member of the corporate ward state. It's as simple as that. And they understand the difference. This is why on their documents they use words of art. They use the word label, they use the word person, they use the word address. All of these things that place you in their jurisdiction, and you unknowingly fill out forms every day, and every time you fill out a form, you enter into a contract. I don't care what kind of form it is. It's a contract. A driver's license application is a contract. A Social Security application is a contract. When you call up the telephone company and you make a verbal contract over the telephone, this is why they can bill you. When you sign a deed, it is a contract. When you fill out a voter registration form, it is a contract. Does everybody understand that? Don't ever think anything that you put your signature on becomes a contract. All right? Now, the fact that you are not in your sovereign status means that you make a contract as a minor. They don't care. They know you are a minor because, and to be other than a minor, you have to be in your proper person at law. And how we write that is this. Can y'all see that? Impropria persona. Impropria persona. When you are in your corporate ward status, you look like this to the court. Pro se. Pro se meaning they get you in the court and they bring someone in called a prosecutor, a prosecutor, because you're in a corporate ward status. Now, if you're in propria persona, say in their criminal allegations, the prosecutor cannot come into the courtroom and say anything to you because you're not in pro se status. Makes sense, right? The issues of law are threefold. The issues of law are status, jurisdiction, and adjudication. The first thing that happens when you walk into a courtroom in your corporate ward status is that they already make the assumption that you are a ward of the state and that you don't know any better. So they immediately start adjudicating you. As the first thing that happens when we walk into a courtroom is that we place our status on the record. On the record. We come in with our flag. We come in with our treaty. We come in with the Constitution we signed with them, and understanding that the Constitution is a contract. It's a contract between who? It's a contract between the United States Republic and the United States of America. But there are certain clauses in that contract that apply to Moors, which takes us back to the Treaty of 1787. But that contract between the United States and the United States of America does not apply to us other than that part that discusses the treaty. So it's not relevant for us to go into any courtroom and argue about their ordinances, their codes, their statutes. The only thing we're in there to talk about is, have we violated the treaty? Have we violated that part, which is Article 6 of the Constitution, that applies to us? That's the only question in the courtroom. Because the status of the individuals looks like this. You and the judge. There's nobody else that you need to discuss anything with in the courtroom besides the judge. The prosecutor is invisible to you. Now, what do you have to say to that judge? My honor, not your honor. What is your status? What is your name? What is your nationality? All right? And do not let them get away with saying, I am a U.S. citizen. You cannot be a citizen and sit a bench. You cannot be a member of the Bar Association, which is a private, non-profit corporation that issues registration numbers to its members who do not have a license to practice law in any state. Because in order to have a license to practice law, you must have your proper person. And in order to be in propria persona in this country, whether that be North America, Central America, or South America, you must be a Moor. If they want to be sovereign, they've got to go home. They cannot be sovereign here. The next issue of law is jurisdiction. Now, let me stick with status. What is the status of the prosecutor? What is the status of the district attorney? What is the status of Lynn Abraham? Does anybody in this room know her nationality? I don't. That's an important question to ask her if she serves me with any papers. Who are you? Where is your license to practice law? Where is your proof of naturalization in my land? Who gave you the authority to be here? Right? Who issued you authority to act in any capacity, to file any complaint or any charges against anyone? That's the question. And I say to you, she can't answer those questions. Right? So then, if you walk into a courtroom and nobody else has the status to be there, automatically challenge the jurisdiction of the court. There's nothing else that you need to say. There's nothing else to be said. Stand mute. Let them proceed, because guess what? They cannot proceed. You have a question.
How do we make them honor that information that you just passed on to us?
In the courtroom, as I have learned, because I've spent a lot of time there, right? There is a language of silence. After you've said what you need to say, don't say any more. They will do the rest when you stand on your square. That's all you need to do. There's no need to stand there and argue with the judge, and trust me, I've done that. All right? And once you say what you need to say, they know everything else to do. But understand, they do not want you exposing the truth to their corporate wards, because every slave that you take out of their corporation, they lose money. This is making business. So don't go into the courtroom trying to expose the fraud. That's not your job. That's not why you're there. There's another venue for that. in that courtroom, because understand it's not court, because it's not law, and I'm going to get into that in a few minutes. So don't try to challenge them on the law. They already know that. They already know they don't have the proper status. They already know they're operating in your land fraudulently. All right? Just say what you have to say and back off. They will give you the window, and it's up to you. If you are educated enough about the law, you'll see the window, you'll recognize it, and then you'll be able to walk through it and walk out the door. But if you're not conscious, when they open the window for you, I'll give you an example, as I gave in class just a few nights ago. Went into the courtroom, and the judge has papers there in front of me, and he's just arguing with me, young lady, you'd better come back here. I'm going to send all these officers I have at my disposal with guns to hunt you down and bring you. And he's just running his mouth. And the prosecutor slides me the paper to sign, and it was blank. Do you understand? Do you understand?
Yes, ma'am.
So I signed the paper, because I know how to sign contracts and not be obligated to them, right? So I did that, signed the blank piece of paper. They took a copy, I took a copy, and I left. And I never heard from them again. But if I had stood there, as I shared with class, and I have done this paper is blank, and I'm not signing it, and right? So all I had to do was come into the courtroom and say what I had to say. Now, I know how to present myself in the courtroom, Islam, right? And see the window and walk out.
Thank you.
All right. Now, the next issue at law is jurisdiction. We already know they don't have the status. Now, do they have the jurisdiction? The answer is no. Because in order to have jurisdiction, you must first prove status. Everybody in the courtroom must have status on the record. Why is that so important? Because unless their status is on the record, what country do you represent? Says what law you're here to get justice on, right? Now, if you have not clarified the status for the record, you can't bring your law into the court. So there can be no court. So status is very important. And so if you're Moore, and let's say somebody else is Manchurian, and I'll get to that in a minute, when you have two people of different standings in the courtroom, you have to decide what law applies. Is there a treaty between the two? Do they have a constitution? Do they have any other trade agreement or contract that binds them and obligates the parties? That's the question. All right? So, if you walk into the courtroom and they immediately start adjudicating, you have no idea what law they're using. And I guarantee you, because status has not been established for the record, they're not using any law that applies to you. And they're not using any law that applies to them. They're simply using corporate policy, which is discretionary. If they like you today, they'll let you off. If they don't like you tomorrow, they'll give you some time or a fine. Okay? So status and then jurisdiction. Jurisdiction is going to determine what area, what geographical area encompasses the authority that that judge or that court has. All right? So if you're in a municipal court or a court of common pleas, don't go in there talking about the Constitution, because they don't have jurisdiction to discuss the Constitution with you. Do not go into a state court discussing the Constitution unless it's the state's Constitution, because the United States' Constitution they have no jurisdiction over, but they won't tell you that. They'll dismiss the case. Different jurisdictions. And don't go into federal court talking about city ordinances. You understand the difference? Okay. Jurisdiction. Then adjudication. Once you get to the part about adjudication, you have to answer the question, do you understand the law that applies to you, that applies to this matter? Because there's two types of jurisdiction. Jurisdiction over the matter and jurisdiction over the person. All right? Does the court have both? They must have both in order to proceed. They don't tell you these things, but this is very important. So if the court has gotten to the point of adjudication, all right, which for me, I don't have that problem. But once the court gets to the point of adjudication, then they're ready to start prosecuting. They're ready to find you guilty of something, some kind of way. And the reason for that is because it's a business. And once you enter there and they seize jurisdiction over you, they adjudicate for the sole purpose of getting some money. That's the bottom line. They don't care about you, whether you're innocent or whether you're guilty, none of that. How much money are they going to get out of this? And their little club that they have called the Bar Association, their members have to be fed. So they want to make sure that this one gets fed and that one gets fed. And that's fine, because that's their corporate thing. That's the way they make money. And if they're going to make money being deceitful and all that, that's the karmic baggage they've got to carry. But you don't want to be a participant to it. That's all. Color of law. Colorable, color, means something that pretends to be something that it's not. Colorable court, colorable money, colorable law, colorable people. Any people who call themselves colored, Negro, African American, Indian, Puerto Rican, Chinese, Australian, all of these are colorable labels, but these people for the most part around the world don't even know this. But because they call themselves Chinese, as I was getting ready to say to you, they are part of a corporate nation state as well, because the country of China is Manchuria. The nation state, the corporate ward nation state is China. That is not the country or the sovereignty of the people. The people are Manchurian. All right? You understand? Say anybody who wants to call themselves Puerto Rican. Puerto Rico is a corporate nation state. It is a private, non-profit corporation that has a charter issued by the Moors, where they have the authority to conduct commerce and trade on the island of Borinquen. Right? Borinquen. That's the name of the people. Borinquen is the name of the island. Puerto Rico is the private non-profit corporation that has the charter to operate within the geographical boundaries of Borinquen. Most Puerto Ricans don't even know that. I go around telling people all the time, you're not this, you're not that. This is who you really are, because people have grown up into slavery for generation after generation in all these corporate nation states who belong to the United Nations, which is a private non-profit corporation trade association for nation state corporations. Got it? In order to belong to the United Nations, you have to be a corporate ward state, nation state. Otherwise, they don't want you. And they will go to war against a country and take the people out of their sovereign capacity and say they're setting up democracy all around the world so that they can take people out of their sovereign capacity and take them away from the law and impose corporate statute on them. And that's exactly what they do. All right? Now, color of law is in full swing all around the world. All around the world. And they have a clique where they're all intermingled and they all agree to participate together in this game. Right? Now, it doesn't matter where you go. Just like most people think you need a passport to travel from company to company to company that are called nation states. So you do need a passport if you call yourself black or African American or a U.S. citizen or any of those things. Yes, you need a passport to travel from one corporate nation state to another. But when you're traveling from one country to another, you do not need a passport. And those countries will tell you you don't. Depends on what you call yourself. You understand? Okay. Why do we have colorable law and colorable courts? During the Civil War, the Moors went to war against each other. Now, we destroyed ourselves in this. The Europeans did not come here and bring us down. We did that from inside, and they capitalized on the carnage. Do you understand? All of these buildings all around here, as I told in class last night, they're ours. They belong to us. They're ancient, these buildings. There's a whole city underneath this city. They've been burned all the major cities, the major energy centers on this globe we called an earth. Our ancestors set up these energy centers that we call Philadelphia, New York, Boston, Atlanta, Detroit, right? Chicago, Miami, Phoenix, Los Angeles. They are energy centers. They're not where they are in huge, large cities just because of some coincidence. There's energy and power in these places. London, Rio de Janeiro, all right? And by the way, we're going to spell it like this, Rio de, which is a normal title of the Moors, Rio de Janeiro. You understand? This thing is worldwide. This flag that we carry with the red flag, with the 5-pointed green star, with the pointing up, all right, is a worldwide flag. It's recognized all around the world, all right? So the reason we have colorable courts and colorable law is because during the Civil War, when the Moors warred against each other, there were those who agreed to participate in the game called the corporate ward game. And there were many who made a lot of money. They got a commission on everybody they got to sign a birth certificate, because the birth certificate is a contract that puts you in slavery. And they got money. William Penn got very rich, all right? All the Quakers got very rich. All the abolitionists got very rich on this Civil War ward state game. Robert Morris and a lot of these buildings that are named after these people in downtown Philadelphia became multimillionaires, and their ancestors are still wealthy today over the corporate ward game. All right? Now, the reason that we have to have colorable law and colorable courts is because so many of us agree to be slaves. We don't need colorable courts and colorable law otherwise. But the people who agree to be bound by the 14th Amendment, which covers civil rights, which covers Negroes and African Americans and Jews and Hispanics and Indians and all these people like that, if you agree to call yourself that, they have to create a statute that applies to you, because law doesn't apply to you. So it's not their fault. It's the fault of the people who agree to be outside of their sovereign capacity. Okay? And now, if you walk in and you want to reestablish it, they're at odds because they're not accustomed to people walking in who are conscious and sovereign. You can't separate the two when you walk into a courtroom. And when I say you walk in on your square, I don't mean standing with your feet at a right angle. All right? I mean not to be deterred when you know you're in the right and you have law on your side. Do not back down. But you do not have to be belligerent. Trust me, I've been there. Don't do that. Okay? Now, the law of the land. The law of the land, as it applies to the United States of America and the United States, is their Constitution. The law of the land, which supersedes that, which if you go and read the Supremacy Clause of the Constitution, you will see that the treaty, in particular the Treaty of 1787, which was last signed and ratified in 1986, all right, it's re-signed every 50 years, that it's the treaty that is the actual law of the land. Now, that being the case, how do we make that treaty work for us? We always say they're not honoring the treaty. This is the oldest treaty in the world. Did y'all know that? And it's the only unbroken and longest standing treaty in the world. Did y'all know that? Now, that treaty protects us. You need to go get a copy of it, the Treaty of Peace and Friendship of 1787, all right, signed by the Emperor of Morocco. Actually, he signed it in the month of Ramadan in the year 1201, all right, which translates into the Gregorian calendar year of 1787, because they added 586 years to our calendar, all right? So, in terms of using the law of the land, and when you express these things to them, you don't even have to go into a lot of detail about it, because those who rule and those in government and those who sit on those judicial benches know what this doctrine is, and they adhere to it. But the problem is there's not enough of us standing up defending it. Okay? How to correct the issue? The people must be in their proper person. The people must act in their sovereign capacity. As the brother said earlier, how do you behave as a sovereign? How do you behave as a sovereign? You behave as a sovereign by not getting so upset and ranting and raving and causing a scene. There's no need to do any of that. As I said in the courtroom, as in with law enforcement and any of that, there's a language of silence. Just like the mummers who march down Broad Street every New Year's and they're playing it up and playing it up. What does mummery mean? Silent mockery. Who are they mocking? Us. All right? But they understand the language of silence, and they deal in it all the time with their secret signs and symbols. But don't be angry with them for using these things. Why not? We taught it to them. Okay? Don't be angry with them because they have gotten out of control with the power that we gave them. We created these people. We can't now turn around and say, now we don't want you, now, you know, go off someplace else and this and that. And if you know the history, you know that the Moors, what the Moors did to these people when they were first created. The Moors considered them subhuman. They couldn't speak Latin, which is our original language. They couldn't go to school. They couldn't own land. They couldn't vote. They were totally disenfranchised. And this is why the Moors commissioned Benjamin Bay, who you know as Benjamin Banneker, who is also Benjamin Franklin, by the way, okay, to teach these people the science of government. He did that for a select few. Unfortunately, it couldn't go and spread as widely as it should have been. Now we have a situation on our hands where we as Moors refuse to be who we are. In the civil rights movement, there were those who led it who were paid to get us off our square, and we agreed to be there. We agreed to be called black, and we're proud of it, remember? Now, who could tell us any different? Now, the Europeans have a dilemma because they've lied to us so much and we have forgotten so much that if they stand up to tell us the truth, would we believe them? The majority of the people who call themselves African American, right now, if you tell them they're not from Africa, they'll give you hell. Am I right? Yes, we are. Now, can you imagine you're getting that feedback from them. Can you imagine what they would say to a European who now try to tell them they're not from Africa? You understand? Now you've got Bill Gates who's given $1 billion to the United Negro College Fund, you know, to keep more Negroes out of their sovereign capacity, and they jump right into the boat, right? Play it up to the hilt. Oh, what a great thing he's done. You know, they love him to death. Now, if the Moors try to stand up and say who the man really is, you got all these black people who are going to criticize you. Leave the man alone, they'll say. All right? But we know the truth. So we correct the issue only by standing on our square, whether we're Moors or whether we're not. All right? Now, let's talk about what law really is. Law is based upon the science of astrology, astrologic. Don't let anybody ever tell you that astrology is for entertainment purposes. It is the science that rules. It is the science that governs. As I said to you, what all law is, all law. All law. Do we praise all law? Absolutely. Do we praise Christ? Absolutely, because what, not who, what is Christ? Christ is the great I am. And if you know what Islam means, let me tell you this. I, self, law, am, master. I am the master of my own fate. I am all law. All right? When you walk into the courtroom and you know these things, trust me, you get a different result. When they ask you your name, you never say, my name is. That's a label. What do you say? I am. I am. You never swear on the Bible. You affirm. You affirm on the Bible. And as Sister Thanai here said to me, oh, they try to trick you. They'll say, do you swear or affirm? No. You just say, I affirm. Because what? I am. And who you are. And that's your status. And nobody can compete with that. Nobody can take that from you. And no matter what paperwork you submit to a court, what is the most important thing is when you walk into a courtroom and you speak the law. And when you speak the law in a courtroom, guess what? You speak it into existence. Because a thought is an activity. It's real. It may not be something you can touch, But as soon as that thought transpires into a word, it becomes a spell. That's why they call it spelling. You get it? Now, law is based upon the zodiac. Now, when you walk into a courtroom, there's all kinds of things going on. There's sacred geometry going on in the courtroom. In fact, the courtroom is set up according to sacred geometry. All right? And here's what happens when you're in there. The judge is at the top of the triangle. Got it? When you walk in there, and as I had shared in another class, to deal with marriage, it's the same thing. And I'm going to talk about that also in a minute. You walk in there, and when you appear, never tell the court that you are appearing. Look in the law dictionary and find out the definition of appear. Never do that. You go into the courtroom and you make a what? A special appearance. Not general. That will get you in trouble every time if you appear in a courtroom. And all of these little nuances, they know these things. And they are put there to trap you who don't know. So when you walk in there and you're on your square, being on your square means to know these things and not to walk in the courtroom uncomfortable. Because when you know them, you have no reason not to come to court, do you? You want to be there because you want to make a special appearance to challenge the jurisdiction of the court. Why? Because of the lack of status. And once jurisdiction is challenged, it must be proven for the record. It must be proven for the record before the court can proceed. Do you understand? The judge must come with his nationality papers. He must come with the flag of the country, not the nation state that he represents. That United States flag with the 50 stars, which now should be 48 because there are only 48 states. Did y'all know that? 2 of them dropped out. Hawaii and Alaska are no longer states. Did y'all know that? They're no longer states. The treaty was up. They got out. I'm kind of going through a lot of things right now. And, okay. All right. The law is used by people in their proper person. When you walk into the courtroom, you should always have your paperwork precede you. Don't walk in there without first having submitted some document to the court to let them know that, yes, I'm coming. And look in the law dictionary and look up the definition of come. It's different than appear. Now, you can come to the courtroom, all right, and make a special appearance. You understand? Never, you get the subpoena, whatever it is in the newspaper, and don't believe all this other stuff where they tell you, don't go to court if you get these papers, because they will put a manhunt out for you, and you do not need that. And there's no reason for you not to go. You should go. You should go, and the more of us that do go and challenge the jurisdiction and let them see we're not scared because we're standing on the square, they will stop calling you to court. All right? Because the people who operate in their proper person, and the more and more of us that go in there operating in our proper person, they're going to begin to see the game is up. The secret's out. We can't do this anymore. All right? Now, this is why when the brother talked about getting our land back, I know this issue very well. I fight this fight every day on top of all my other duties and responsibilities and everything else that I do. So when we talk about justice returns under the age of Aquarius, this is why when we walk into a courtroom and we understand that the court, as I explained to a class just recently, a court is also a corporation. They don't hide that from you. They put it right on the seal, right behind the judge. And they tell you that this court was incorporated in 1878, whatever it is. This court was incorporated, and what words do they use? Founded. So when you see the word founded and you see the word established in, it already tells you that they're a corporation. Understand? And anybody who owns a corporation does what? Own a slave. Because a corporation is a slave holder. Understand? Now, let's talk about the issues that come up in court. How am I with time, Noah? All right. The point I want to make real quick relative to going to court and getting land back and all these issues and all these injustices that have been done to us, when we participate in organizations that take us off our square, that adds to the chaos and the confusion. So it's better not to join anything at all and just be yourself if you're not going to be a Moor. But even if you're going to be a Moor, understand that sovereignty is an individual thing. Don't go into court talking about, I belong to such and such organization. And be clear about that, because as soon as you say an association, an organization, a business, a firm, a corporation, you're talking about slavery. And they love that language, because you're putting yourself right in their jurisdiction as soon as you say it. But you go in there and say, I am. Well, what organization do you belong to? Well, none. They do not know how to deal with you. But as soon as you say corporation, because they're a corporation and they speak the corporate language and they have corporate policy, they'll love you to say that. So the first thing they're going to do is, how are we going to get some money? All right? Because that's the name of the game, money. Now, let's talk about who they are, why they exist, these courts. First of all, we know they're not really courts. We know they're colorable. They know they're colorable. They have to be colorable because they're dealing with colorable people, right? If we choose not to be colorable, we don't belong in there. So, the court is this. Just like the Commonwealth of Pennsylvania, just like the Bar Association, just like the United States of America, they are this. They are a private nonprofit corporation. If you get some mail that belongs to me, do you go and show up and say you're me? No, you can't do that. So if a private nonprofit corporation sends you a document and you have no contract with them, why should you go up and debate the contract? Because if you don't have a contract, right? If you don't have a contract, you don't have a contract. It's as simple as that. You don't need to go there and say all that. Just say, because here's my status and this and that and the other, right? Don't go in there trying to debate whether you owe money on the contract or not. The bill was too high and all that. And I'm not saying that because of what you said. Understand that. If you don't have the contract, why are you discussing the bill? It doesn't make sense, does it? First, you have to have a contract. So the first thing you need to understand when you walk in there, I don't care what the issue is. Here's the question. And I write things down, specific things I write down, because when I write them down, I'm spelling. Understand? Do we have a contract? If I rescind my birth certificate, do I agree to belong to the corporate ward state that calls itself the Commonwealth of Pennsylvania, which is a private nonprofit corporation? If I don't have a birth certificate with you, what agreement do we have that you should summon me to answer anything? Right? If I don't have an agreement with the parking authority, which I don't, do they have the right to send me a bill saying that I owe them for a parking ticket? It's ludicrous. Now, the thing to say is, if you don't have the contract, you have certain rights, and you need to exercise those rights. And there are codes even that are there, and laws that are there to protect you if you don't have a contract with somebody and they're trying to make you adhere to a contract. I don't care what kind of contract it is. If you don't have a driver's license and they pull you over, the first thing you need to say is, I don't have a contract. They may still give you the ticket, but understand that there are other things, which I already explained, in the language of silence, which, because we are amongst non-Moors tonight, I will not show you. However, there's a language of silence that you can speak to these people and they will not bother you. You can trust me on that. However, if you are not comfortable and you happen to get off your square and you get the ticket and you have to go to court, that's the first thing you have to say. I don't have a contract. And all of these courts, because they are corporations, the only type of policy they can deal with is contract policy, not contract law, contract policy. So the first thing you must ask is what? Do we have a contract? And if the answer is no, then I'm here under threat, duress, and coercion. You are violating my rights. It's as simple as that. You have no other reason to be there. Does that make sense? Okay. If the state comes in and says, you're not treating your children right and we want to take them, right? The first thing you have to say is, state, do I have a contract that says I gave my children to you? Did I, at what point, produce the contract? Produce the contract. If you send me a bill, and understand that if you belong to the corporate board state, you can't make these arguments because you do have a contract, which is the birth certificate, which is the marriage license, which a marriage license is your contract, is the woman's contract with the state and the man's contract with the state. It's not a contract between the man and the woman. Never was, never will be. Unless you have a prenuptial agreement or something else, you don't have a marriage contract with the one you think you love. You have a contract with somebody else who becomes a third party to your life, always, till you rescind the contract. All right? Because that's not how you get married. Marriage is under all law. All right? And then what you're responsible to do is to place the oath that you take between the two of you on the public record. Where? Where do you place information on the public record? Do you know? With the county. The counties are ancient. They belong to us. They belong to us. Our ancestors named the counties. Our ancestors formed the counties. Our ancestors set up the government of the counties, and the counties operate according to common law. Did y'all know that? The counties belong to us. So let me write this for you. How many of you think you live in Philadelphia County? For those who, okay. Okay. All right. Here we go. See that? Do you recognize that there's a difference between the two? There's a difference between Philadelphia County, which our ancestors set up with certain geographical boundaries, and that corporate, nonprofit corporation that calls itself the County of Philadelphia. It is a corporation chartered to conduct business and commerce and trade and all that within the geographical boundary of Philadelphia County. They are two different things. They are two different things. So when you see documents, pay attention, because all documents that you get don't have County of Philadelphia on them. And you know the difference between the two, because if you get documents from the County of Philadelphia, you know that you're receiving correspondence from a corporation. Do you understand? And if you're receiving correspondence from a corporation, the first question you must ask is, do we have a contract? Now, if you receive correspondence from the county, that's common law. You have the responsibility to respond and adhere to that, because guess what? You are a part and parcel of that county. Our ancestors set up these geographical boundaries for us, all right? Now, likewise, with any other county or city, pay attention to this one little word. It's a very dangerous word. I'm going to tell you. And as I tell people in my class, when that word shows up, you're in trouble. The reason is because most of you prior to tonight, you didn't understand that there was a difference in when they used that little word of. But trust me, there's a difference between whether you're dealing with government or corporation. Government or corporation. You have to know the difference. And if you don't know the difference between these things, they're going to have you swinging left and right in the dark and hitting nothing. Okay? I want to explain to you that when you're dealing in contracts, your status in the contract is very important. How do you establish your presence in a contract so that you are protected? Does anybody know how to do that? Because we're confronted with contracts all the time, and when we do not adhere to certain terms and conditions of the contract, which we did not understand from the very beginning, then we're dragged into court to answer for all kinds of claims and allegations on behalf of the corporation, and we don't even understand why we're there. We think, for the most part, the majority of us, and prior to tonight, you get a summons to appear in court. I don't care whether that's a civil action or a criminal action. You are on the defensive because you feel that inherently, maybe I have done something that warrants these allegations, even if you know for a fact that you're innocent. Because the way that corporate system operates, you are not innocent until proven guilty. You are guilty until proven innocent. And the reason is because, as some of these state sovereignty people would have you believe, the United States has declared war on the people. We're in a state of martial law. Well, of course you are. If the people have agreed to be corporate wards of a state that's a private nonprofit corporation, and the government operates according to sovereignty, and you agree not to be sovereign, then what have you done? You've abandoned your government. The only thing the government can do is declare war on you. That's why you walk into a military tribunal when you walk into these courtrooms. That's why they have a military flag, which is a USA flag with the gold fringe, that lets you know you're in a military tribunal. And the reason is because you've agreed not to be sovereign. So the only way they can deal with you is in a military fashion. Y'all understand that? Okay. So how to protect yourself when you're dealing in, the first thing, I'm not going to really get into details of explaining to you how to stand on your square and how to be in court and all that. The first thing you must understand is how to exist in contracts. Because if you understand how to exist in contracts, that will significantly reduce your ever having to go to court, to the courtroom. Okay, to the courtroom. If you understand how to deal in contracts, because all these corporations do is deal in contracts, and all the these court systems, let me say that, do is deal in contracts. So if you're not familiar with the contracts, and the majority of their contracts are these, adhesion contracts. Look in the law dictionary and look up the word adhesion, and what you're going to find is that an adhesion contract is a type of contract where there are terms and conditions that are a part of the contract of which you are not aware. And every time you sign a birth certificate, there's the balance of that contract is somewhere. Whenever you sign for a driver's license, the balance of that contract is somewhere. You don't have it, you've never seen it, but it does exist. And this is why they have the authority to issue you a ticket for all these different things and violations, because there's a contract somewhere that you've signed and you have not reserved your rights. So if you don't reserve your rights are considered waived upon signing of the contract, which means that you know, understand, and agree that there's an adhesion going on, and you don't care, or you otherwise are not aware. They don't care. They've got you to sign. How do you go back now and correct the fact that you signed all these adhesion contracts everywhere all your life? You've signed them. I know you have, because I have too. And now's the time for you to get back into your proper person so you can correct those contracts and get out of the ones you don't want to have, and the ones you choose to have, you can exist under your own terms and conditions. That's the most important part. That's long before you get to go into court. Because you can go to court all day long, but guess what? Unless you correct the problem, the root of the problem, which is not knowing how to exist in contracts, you'll constantly go to court, and that's a waste of your time. I'm sure you have many more productive things to do than to keep showing up in court, making special appearance in propria persona, sui juris, and stating your status for the record. Okay?
All right, everybody, I'm back, and I hope you took notes from what the sister said. Very, very powerful information. Some of the best set of videos that I've ever seen. I want to run over a few other things for you because we're still dealing with the stuff of not only your nationality, but operating in the private, man. We're talking about doing this thing in the private. We want to avoid the word organization. We want to look at it from a position of trust, and you are operating in the private as a family. Let's talk about dutiful attention. After setting up a trust, the major focus becomes administration. It is always best to look before one leaps. So now is the time to become familiar with the skills and talents needed to handle a trust. Getting a trust turns the family into a business, conducted as one. The product is the children. The goal is better life for all involved. In this capacity, the trust supports the beneficiaries. Of course, for tax purposes, a trust is pass-through entity, referring to a trust as a business. Other than within the context of this discussion, blurs the lines of legal definitions. Do not use the term business when filling out forms. Use the term trust. Okay, then we go over here. And let's back up for a minute, and let's talk about the grantor. Organizing the trust makes significant amount of paper. It takes a significant amount of paperwork. An important amount of time is spent making trips to the banks and other institutions. As the trust matures, the volume of paperwork drops to a routine and easily managed level. Also, this part of the administration should be handled mostly by the trust executive secretary, who is in a unique position to keep the proper procedures and to ensure trust documents are treated correctly. Should the executive secretary not be inclined to deal with all of the details of the paperwork, he or she may delegate them to a secretary or secretarial service. An oath of privacy, a confidentiality agreement needs to be signed. This individual or group can assemble or produce all necessary documents and deliver them for the executive secretary's review and signature. The board of trustees will most likely meet either monthly or every 2 months or quarterly during the first year, after which the frequency will either increase or decrease, depending on the trust activity. It may meet as rarely as once a year if the activity level is low. An active board develops a strong camaraderie as the members interact with the grantor and get to know one another. As mentioned above, this cohesiveness is one of the greatest strengths of a family trust. People who support and rely on one another can be a force to deal with should any outside interest threaten to disrupt the smooth operation and regular cash flow of a trust. Now, this is very, very important information, and I just want to give you some insight into the workings of a trust. And I would like to recommend, I don't think I recommended the last time I did a video, I'd like to recommend that you get this book here. That will give you some details on the inner workings of the United States of America and what occurred, and where we are, and what's going on. Very, very important for us to understand that. The creature from Jekyll Island, okay? Now, also, I mentioned to you about getting to know the people involved in your trust. This is another book that I found very, very interesting. It's called Know the Name and Know the Person, okay? And this deals with the individual's name, the vowel in the names, what it means, and all of that good stuff. And of course, I've already shown you this once before. I use this quite frequently. In fact, this is my second copy of this book that I had to buy because the other one was so worn out till I just decided to give it to someone and go ahead and get another copy of it. The New Astrology by Suzanne White. Now we come to the granddaddy here. I mean, not granddaddy, the grandmother. It's called Love by the Numbers. Glennis McCann's. This deals with numerology, and then we got Numbers and You. Numerology Guide to Everyday Living. This deals with the science of numerology, and these books help you get to know people. And this is why I deal with these books. It helps me get to know people regardless of what your race is, whether you're male or female. These are some of the books that I use to get to know people. Okay? Now, we're going to be going into another segment. I'm not trying to make this a real long video, just to bring this stuff in and let these people drop this information. But we're going to give you some information from a whole nother perspective, or from what is commonly referred to as a common law perspective. But keep in mind that we're still talking about operating in the private. I don't use the word sovereignty. I use the word man or woman or men or women or what have you. But it's very important for you to know the definition. And we talked about that earlier, knowing the definition of the terminology and doing the etymology on words and what they mean and all this stuff, so you're able to sort through this stuff. And after we get through with that, then I'll be closing out this video, and then we'll be coming back at a later date doing some other things. I just got off the phone, Brother Reggie. He'll be down here, and we'll be dealing with getting private automobiles and all of that old stuff and the paperwork. And then I'll be coming out with other paperwork and stuff so you can see this stuff. I won't do that today. I just want to make this an introduction to the series of videos that we're going to be doing coming up in the future, involving this law, operating in the private, operating through a trust, getting to know people, how to deal with your nationality, involving this stuff and making it all work for you. Okay? All right, so y'all hold on, and we're going to go to the next segment. And make sure you got your pencil and paper handy so you can write down this stuff and you can get to know it. Be right back.
Okay, so today we're talking about do-it-yourself, no property taxes. And so let's get going. We are all products of the government's educational system. The government has taught us what we need to know to operate in their system, but have they taught us everything? Many of our problems are self-inflicted because of our own ignorance. Okay, Mark Passio, a former Satanist priest, has a great channel on YouTube about natural law. Talks about natural law, order followers, pillars of Satanism. Anyways, one of the things he says, he goes into a derivative of words, and he says ignorance, the root is ignore. And so he calls it ignorance. And so many of our problems are self-inflicted because of our ignorance. And so if we want to have true ownership, if we want to really own our land, if we want to really be free, then we need to understand what that means. And owning your own land is a very important part of it. And so these are some self-inflicted problems that we're going to talk about here today. Did you pay for your land with Federal Reserve notes or their equivalent? Can the bail priests in the so-called courts presume that you use Federal Reserve notes or their equivalent? Was the payment shown in the deed? Was it pesos or was it dollars? Okay, that first symbol there is pesos, the one with one vertical bar, and the one with two vertical bars is dollars. Did you have a mortgage? Okay, only a U.S. citizen can access bankster debt, and if you're a U.S. citizen, you're a slave, you're a piece of property, they can just take whatever they want. You have no rights. Can the bail priest and the so-called courts presume that you're a U.S. citizen? You know, these are all questions we have to ask. You know, do you know who you are? Your land is one of the fundamental things to being truly free. And the Founding Fathers understood this. We're going to talk about that today. This is the Gold Reserve Act of 1934, located at 48 Stat 337. Says in Section 15, as used in this act, the term United States means government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. So think about what they're saying here. They're saying that Federal Reserve notes are meant for internal use of the government only. Okay? And if you use Federal Reserve notes, you're saying that you're a government employee. And so, therefore, a U.S. citizen. And so, therefore, you don't have any rights. That's what it says. Title 12, Section 411 says Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to Federal Reserve banks through the Federal Reserve agents as hereinafter set forth, and for no other purpose are authorized. The said note shall be obligation to the United States. So they're evidence of debt. And they're not authorized for use for anything except for the Federal Reserve banks. So, again, do you know who you are? Do you know what you're doing? You know, most people are so ignorant, they don't have a clue. And they go and sell themselves down the river, and then they wonder why they're a slave. There's this distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation to the operation of the discharge. Federal Reserve notes discharge a debt. They don't pay anything because they're not money. A promissory note, a written promise to pay a certain sum of money at a future date unconditionally. A promissory note differs from a mere acknowledgement of debt without any promise to pay, as when a debtor gives his creditor an IOU. Okay, that's what a Federal Reserve note is an IOU. Okay, and it's drawn on the privately held Federal Reserve Bank. It's not even on the U.S. Treasury. It's on the privately held Federal Reserve Bank. When you spend a Federal Reserve note, it's a bill of credit. You're buying something on United States credit. That's why they charge the tax. Because you're using the privilege of using this United States credit to buy something. So then think about it. Who owns it? The United States owns it. This is this is an act which was approved the 16th Congress, that credit shall, an act making further provision for the sale of public lands, okay, in 1820. And then Section 2, it says, and be it further enacted that credit shall not be allowed for the purchase of money on the sale of any public lands which shall be sold, okay? They wanted no credit to be allowed, okay? And these people understood the power of having your own land. And this is a quote by Senator King of New York in March of 1820. This is in the Congressional Record. It was calculated to plant in a new country a population of independent, unembarrassed freeholders, that it would place in every man the power to purchase a freehold, the price of which could be cleared in 3 years, that it would cut up speculation and monopoly, that it would prevent the accumulation of alarming debt, which experience proved never would and never could be paid. They understood. But we, the people, are asleep at the wheel. We don't have a clue. We are so ignorant, it's a wonder that we can even tie our own shoes in the morning. This is Supreme Court, 1863. We are then to regard the revolution in these acts of assembly as emancipating every acre of the soil of Pennsylvania from the grand characteristic of the feudal system. Even as to lands held by the proprietaries themselves, they held them as other citizens held under the Commonwealth, and that by a purely a title purely allodial. All our lands are held immediately or immediately of the state by the titles purged of all the rubbish of the Dark Ages, excepting only the feudal names of things not any longer feudal. Under the Acts of Assembly I have alluded to, the state became the proprietor of all lands, but instead of giving them like a feudal lord to an enslaved tenantry, which is what everybody is today, she has sold them for the best price she could get and conferred on the purchaser the same absolute estate she held herself. And these have been reserved, and everything else has been granted by contract. Don't see that anymore. After the American Revolution, lands in this state became allodial, subject to no tenure nor to any services incident thereto. This is another court case, 1839, quoted again in 1925. From what source does the title to the land derive? From a government spring, and arbitrary governments from the supreme head, be he the emperor, king, or potentate, or by whatever name he is known, in a republic, from the law making or authorizing to be made the grant or sale. In the first case, the party looks alone to his letters patent, in the second to the law and the evidence of the acts necessary to be done under the law, to a perfection of his grant, donation, or purchase. The law alone must be the foundation from whence the authority is drawn. There can be no other source. The land patent is the muniment of title, such title being absolute in its nature, making the sovereigns absolute freeholders on their lands. Finally, the patent is the only evidence of a legal fee simple title. And that's Illinois, 1837. And so, again, there is no such thing as a sovereign that does not have land. There is no such thing as a sovereign that does not have land. This is the act that started all of the so-called taxation that you see today on land, property taxes. And this is 12 Stat 292, August 5th, 1861. And this is an act to provide increased revenue from imports and to pay interest on the public debt and for other purposes. And so this is the act where it got started, and we're going to go through it. Section 8, it says that a direct tax of $20 million be and is hereby annually laid upon the United States, and the same shall be and is hereby apportioned to the states respectively in the manner following. Section 9, I'm not going to read the whole thing. It says that they're going to appoint an assessor and a collector for each district. Okay, the President of the United States is hereby authorized to divide respectively the states and territories of the United States and the District of Columbia into convenient collection districts, and to appoint an assessor and a collector for each district. And it be further enacted that before any collector shall enter upon the duties of his office, he shall execute a bond. That's Section 10. Section 13, the said direct tax laid by this act shall be assessed and laid on the value of lands and lots of ground with their improvements and dwelling houses, with several articles subject to taxation shall be enumerated and valued by the respective assessors. Section 14, it talks about that respective assistant assessors shall immediately after being required, as aforesaid by the assessors, proceed through every part of their respective districts, and shall require all persons owning, possessing, or having care or management of any land, lots of ground, buildings, or dwelling houses, okay, under the authority, and it goes on, under the authority of the respective states, okay? So the point being is that it's persons, it's U.S. citizens. Section 29, that as soon as said Board of Assessors shall have completed the adjustment and equalization, okay, so this is what set up the equalization boards and the adjustment boards of adjustment that exist to this day. Section 43, and this is basically the beginning of Title 18 United States Code, Section 241 and 242, violating people's rights under the color of law. And be it further enacted that every collector is deputy who shall exercise or be guilty of any extortion or oppression under color of this act. Section 48, they get a commission. They get a royalty Back then, it was a commission of 4% upon the first $100,000 and 1% on the second $100,000 and 0.5% on all sums above $200,000. So who knows what it is today, but they're collecting a royalty. They're motivated. They don't care whether you owe that tax or not. They're going to do everything they can to steal it. They're nothing but thieves. They're Satanists. And then there's the Homestead Act. This is an act to secure homesteads. People always ask me about the homesteads. To actual settlers in the public domain. Okay, this is 1862. And Section 2, it says that the person applying for the benefit, okay, so they're converting a right into a privilege, and it's for U.S. citizens again. Why would you want to apply for a privilege that a U.S. citizen has when you have the right anyways? This is 1862, Section 4. That no lands acquired under such provisions of this act shall in any event become liable to the satisfaction of any debt or debts contracted prior to the issuing of the patent, therefore. So again, they're talking about the homesteads again, and they're talking about how they're basically putting a Band-Aid on the screw-up they did with the act in 1861. A person is only a fictitious entity. This is at 16 Stat 431. This is an act prescribing the form of enacting and resolving clauses of acts and resolutions of Congress and the rules of construction in 1871. Be it further enacted, all act hereinafter passed, the word person may extend and be applied to bodies, politic, and corporate. So it's U.S. citizens. An act concerning the construction of statutes in Arizona. Okay, now this is actually the Legislative Assembly of the Territory of New Mexico, because Arizona at one time was part of New Mexico. And it said this is first day of December 1851 in Santa Fe. Section 1, the construction statutes in this territory, the following rules should be observed. The word person may be extended to bodies, politic, and corporate. This is for the territory of Arizona, which was approved. This is for an act to provide a temporary government for the territory of Arizona, which was an act of Congress. And 1863, together with all the legislative enactments of the territory of New Mexico not inconsistent with the provisions of this act, are hereby extended to and continue in force in the said territory of Arizona. That's located at 12 Stat 665. And this is the federal codes, which is some liar's opinion of what the statutes say. 26 U.S.C. 7701. When used in this title, where not otherwise distinctly, expressly, or manifestly incompatible with the intent thereof, the term person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation. It's a fictitious entity. Include, or the participial form thereof, is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. Okay, include is limiting. Include, this is American Dictionary of English Language, Noel Webster, 1828, to confine within, to hold, to contain, as a shell includes the kernel. And then Black's Law Dictionary, 6th edition, include, to confine within, to hold as an enclosure, take in, attain, shut in. Okay, so when they say the term person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation, it means nothing else. Under the International Law Rule, this is a publication that's published by the federal government, the jurisdiction over federal areas within the states, a report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the states, Part 2, a text of the law, the legislative jurisdiction, submitted to the Attorney General and transmitted to the President in June of 1957. And this is page 158, which is the beginning of the site that I want to show here. An International Law Rule. Federalizes state civil law, including common law. The rule serves to federalize not only statute, but the common law of a state. Okay, and so all state statutes are actually federal. And And it goes on page 165. The civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws. And if you happen to be a U.S. citizen, the courts have ruled numerous times that the District of Columbia borders expand as needed to anywhere in America for U.S. citizens. So if you're a U.S. citizen, then you have federal jurisdiction. Originally, Congress intended that land could not be encumbered in any way. Property taxes were originated by an act of Congress in 1861 for U.S. citizens. The Homestead Act is a privilege for U.S. citizens. State statutes are actually U.S. statutes. If you used, or the bail priest in the so-called court can presume that you used, Federal Reserve notes to pay for land, then it's not paid for. Federal Reserve banknotes or other notes constituting a part of the common currency of the country are recognized as good tender of money unless specifically objected to. A dollar is a legal currency of the United States. The unit of money consisting of 100 cents, the aggregate of specific coins, which add up to $1. In the absence of qualifying words, that cannot mean promissory notes, bonds, or other evidences of debt. Banknotes constitute a large and convenient part of the currency of our country and by common consent serve to a great extent all the purposes of coin. In themselves, they are not money, for they are not a legal tender, okay? So they made them legal tender, but they're still not money. And yet they are good tenders unless specifically objected to as being notes merely and not money. They serve the purposes of money in the ordinary business of life by the mutual consent of the parties to a contract not having a binding force of any common usage, for the party to whom they may be tendered has an undoubted right to refuse accepting them as money. And you still have that right to this day. A banknote resembles a common promissory note issued by a bank or corporation authorized to act as a bank. It is in fact a promissory note, but such notes are not for many purposes to be considered as mere securities for money, but are treated as money in the ordinary course and transactions of business by the general consent of mankind. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States. That is U.S. Supreme Court, people. Federal Reserve notes are IOUs. They're forced loans. They're legal tender. You are forced to loan the government money because they're bankrupt and they're run by a bunch of thieves. So what's solution number one? Solution number one is to object to the IOUs circulating for money. At common law, only gold or silver were legal tender. Okay, at common law, if you want common law, then you got to have honest measures. If you tender Federal Reserve notes, you will never get common law. Okay? Hell will freeze over before you get common law if you tender Federal Reserve notes. If you want common law, then you must have honest measures. If you want lawful land, then you must defeat the bail priest presumptions. If you want to be a state citizen instead of a U.S. citizen, then you have to quit doing things that U.S. citizens do and start doing things that state citizens do. If you want to have all the rights and privileges of a land patent, then you need to bring those rights and privileges forward. Real property, that which consists of land and all the rights and profits arising from and annexed to land of a permanent, immovable nature. In order to make one's interest in land real estate, it must be an interest not less than for the party's life, because a term of years, even for 1,000 years, perpetually renewable, is a mere personal estate. Okay, so there's a difference between real property and real estate. Real property is land and everything that's attached to the land. Real estate is real property that you have an interest in, but you do not own it. Okay? Remember, if you go back to here, it talks about parties. Okay? A party is a person. It's a U.S. citizen. Estate, real property, is you have an interest in it, but you do not own it. Estate is the operative word. An estate is something you have an interest in, but you do not own, like your father's estate. Title, estates. A title is defined by Lord Coke to be the means whereby the owner of lands hath just possession of his property. This is the definition of title to lands only. And so there was actually about 8 or 9 different definitions, but we're just going to cover a few. So number 3 is a title is either good, marketable, doubtful, or bad. And number 5 is a marketable title is one which the court of equity considers to be so clear that it will enforce its acceptance by a purchaser, okay? The doctrine of marketable titles is purely equitable and of modern origin. At law, every title not bad is marketable under these equity Satanists. At common law, doubtful titles are unknown, where every title must be either good or bad. So at common law, it's either good or bad. And under equity, they just do whatever they feel like doing. They're a bunch of Satanists. Authorities hold that to render a title marketable is not only necessary that it be free from reasonable doubt, in other words, that a purchaser is not entitled to demand a title absolutely free from every possible suspicion. So it's not a perfect title. A bad title is one which conveys no property to a purchaser of an estate. Title to real estate is acquired by 2 methods, namely by descent and by purchase. It's passed on in your family or you buy it. You convert gold or silver to land. These deeds include the ones as follows: a warranty deed, a quitclaim deed, sheriff's deed, trustee's deed, judicial deed, tax deed, will, or any other instrument that purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title. Color means an appearance, a semblance, a simulacrum, as distinguished from that which is real. It's a fraud. A prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise, or a pretext. Colorable means that which is in appearance only but not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. A fraud, a lie. Color of law, the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state is action taken under color of law. When we say a person has a color of title, whatever that may be the meaning of the phrase, we express the idea at least that act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him. There, the complainant seems to have relied upon the tax deed as conveying to him the fee, and to sustain such a bill, it was incumbent upon him to show that all the requirements of the law had been complied with. Obviously, this case is a case where a tax deed is very colorable, and a tax deed really doesn't convey anything. And somebody went and paid for a tax deed from the thieves, and whoever the thieves tried to steal it from objected and happened to understand the law. And so the court here was basically saying that the guy bought a tax deed, but he didn't get anything. He bought nothing. Land titles come in various forms: general warranty deeds, special warranty deeds, sheriff's deeds, judicial deeds, quitclaim deeds, land patents. A general warranty deed is where the seller warrants the title to be free of all liens and encumbrances. A general warranty deed is generally what's received in order to get a mortgage before the bank will authorize the mortgage. A general warranty deed is considered to be marketable title. A special warranty deed is where the seller will warrant the land free of all liens and encumbrances with some reservations. That's usually like when it's a foreclosure or something, or maybe a tax sale. Okay, and so they're trying to cover their backside. They're thieves. A special warranty deed is usually used when the land is subject to a foreclosure or tax sale. A special warranty deed is considered marketable title. A sheriff's deed is when the sheriff sells a piece of real property. Could be from a foreclosure or tax sale or something like that. Could be something else. Sheriff's deed is considered marketable title. A judicial deed was when a judge orders the real property sold. Could be an estate or something like that. Judicial deed is considered marketable title. A quitclaim deed essentially says that the seller transfers his interest in a piece of property. Property sold because of a tax sale is usually transferred by a quitclaim deed because the tax thieves know they don't have any interest in the property. They're saying, we sell you this interest, whatever interest we have in the property. A quitclaim deed can transfer title as effectively as a general warranty deed. Actually, what happens is when people pass it on in their family, the father passes it to the son, he'll just give his son a quitclaim deed. Okay, it's been in the family for generations, and it's perfectly fine. A quitclaim deed may transfer nothing. A quitclaim deed is a deed of conveyance operating by way of release that is intended to place any title, interest, or claim which the grantor may have on the premises. So I don't know how many times if you've heard of the Brooklyn Bridge being sold. Okay, it has actually been sold a bunch of times, but it's owned by the state of New York. And every time it was sold by a quitclaim deed. Somebody claimed they had an interest and they sold it. And, you know, it's a scam. A patent to land issued by the United States under authority of the law is the highest evidence of title, something upon which the holder can rely for peace and security in his possession. It is conclusive evidence of title against the United States and all the world. Nothing but a patent passes a perfect and consummate title. A patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong, to land described in such a patent can prevail at law against the patent. Equitable is talking about a mortgage. Okay, so if you do it right and you defeat the bail presumption, then you might win. A patent is the highest evidence of title and is conclusive against the government and all claiming under junior patents or title until it is set aside or annulled by some judicial tribunal. Issuance of a government patent granting title to land is the most accredited type of conveyance known to our law. A patent is intended to quiet title to and to secure enjoyment of the land for the patentees and their successors. Thus, a quitclaim deed, a quitclaim deed, a land patent conveys whatever interest the government has in the soil and the land. Well, think about what they're saying there, okay? Because the government gets the land in a lot of different ways. Matter of fact, some people say they stole it from the First Nations people that were here first. And there's good reason to believe they probably did. And so, again, whoever has the land, if they can show that they have a better, superior claim to the land, then that's going to be a problem. As we have noted in connection with the patent by the United States, the patent's effect is the same as though the United States has executed a quitclaim deed. A patent operates as a deed of the government. As a deed, its operation is that of a quitclaim. It passes only the title the government has on the date of the patent. A patent to the United States as a deed, its operation is that of a quitclaim and rather of a conveyance of such interest as the United States possessed in the land. Again, that's U.S. Supreme Court. A land patent is the highest best title, but at the same time it's a quitclaim deed. If a land patent is a colorable title, then what would be true loyal title? Quite frankly, it's all coral title. If you get a First Nations title, if you get a First Nations de jure chief to grant you a patent on some First Nations land, I bet you could grant you a patent on, you know, I don't know about the land under Congress, but you could certainly grant it under some legislature somewhere, and you'd probably get it. There is nothing here requiring a deed to establish a color of title, and under the former decisions of this court, color of title may exist without a deed. You know, that's squatters' rights. Think about it. You sit on the land for 7 years, it's yours. The courts have ruled that the government has to settle all the land claims of the First Nations. They're essentially saying that the government stole their land. This is a crown patent in Canada, and you notice how it's in a box, and you notice how they sold it to a company, and all the numbers and everything are all spelled out. It's and then we're going to look at it. This is a Santa Fe Pacific Railroad Company patent. This is 501639. And so there's different kinds of patents. I've got Texas patents. I've got a bunch of different kinds of patents. But we'll just talk about these ones today. This is the Phoenix Land District. And it says here, whereas by act of Congress approved July 27th, 1866, an act granting lands to aid in the construction of the railroads. This is one of the railroad patents. So they granted the railroads 10 miles of land on either side of the railroad, wherever the railroad went, to finance or to help the railroad pay for the railroad. Anyways, so it basically goes through and talks about that, basically, is what it talks about. And it says, then next paragraph, it says, if you want to pause it and read it, you're welcome to. Whereas official statements bearing dates December 17, 1880, I mean, it goes on. And then the next page, it says, whereas certain tracts of land have been listed by the duly authorized land agent of the Atlantic and Pacific Railroad Company, as shown in this original list, approved by the local officers and now on file in the General Land Office, whereas it is shown by evidence filed in the Office of the Secretary of the Interior that the Santa Fe Pacific Railroad Company was under a purchase at foreclosure sale of the property and rights of the Atlantic and Pacific Railroad Company, and by compliance with the acts of Congress approved March 3rd, 1897, became the lawful successor in interest of the Atlantic and Pacific Railroad Company. So they're showing that they're basically saying that originally the Atlantic and Pacific Railroad Company was entitled to it. They went bankrupt, and the Santa Fe Pacific Railroad Company became the owners in the bankruptcy. Whereas the said tracts of land lie coterminous with the construction line of the road within 40 miles thereof, and are particularly described as follows, to wit. Okay, now one of the things that I want to talk about here is legal descriptions. And in every state, they have a base and meridian, okay, and where they take all the legal descriptions from. And Arizona, it's the Gila and Salt River Meridian. Okay, and so that's where they take all the legal descriptions from. And then then if you read this, it's Township 18 north of Range 20 east. And so basically they have a line that they draw that's on the land, and then they divide it into ranges. Okay, so the meridian is vertical, and the ranges are horizontal. So you figure a meridian is vertical on the earth, going up and down, north and south, and the ranges are horizontal, east and west. And a township, so you got Township 18 north of Range 20 east. Okay, so Range 20 east would be 20 ranges north of the Gila and Salt River Meridian, which is 6 miles. Okay, so a township is 6 miles, so each range is going to be 6 miles, because the range defines the township boundaries. And so 6 times 20 is 120. And so it's 120 miles north of the meridian. And Township 18 north, okay, so then it'll be Township 18, they'll be numbered, north of Range 20 east. Okay, so Township 18, so that'll be east or west, and I'm not sure which way it'll be. I'd have to look at the map to see it. But anyway, so they got this township defined, and they're talking sections 1, 3, 5, 7, so that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 sections in a 36 section township. Okay, so it's about half of the township, not quite. 15, so it actually 18 would be half, so it's only 15. It's not quite half of it, but it's half of the township. So anyways, just so you know how these legal descriptions work. Anyways, so each township is 6 miles by 6 miles. The range is going to define the northern side of the township and the south side, and then you'll have a 6 miles east and west, and then so that'll be Township 1, or they'll number them. They'll start numbering them, and I'm not sure which way they do it in Arizona, but it'll be 1, and then 2, and then 3, and then 4, and to the borders. So this is Township 18, which is north of Range 20 East. And so that's up in northern Arizona, obviously. That's actually some land I bought is in this parcel. Anyway, so you can see it's just a big, huge list. Okay, I don't know how many townships or how many sections are in here, but there's a bunch of them. And it's basically, 10 miles on each side of the railroad, wherever that railroad was going. And it's a big, huge list. Oh, and it says here at the very end of this list, it says containing in the aggregate 260,334 and 5,300 acres. 260,334 acres. Wow. It's a bunch of land. And then it goes on, it says, know ye that the United States of America, in consideration of the premises and pursuant of the said acts of Congress, has given and granted by these presidents, does give and grant unto said Santa Pacific Railroad Company successor in interest to the Atlantic and Pacific Railroad Company and to its successors, and assigns the tracts of land listed as aforesaid and described in the foregoing to have and to hold the said tracts and with the appurtenance thereof unto the Santa Pacific Railroad Company successor as aforesaid and to its successors, and assigns forever. It doesn't say a word in there about property taxes. It doesn't say a word in there about reserving mineral rights. It doesn't say a word in there about anything. And most of them don't. And there on the same page at the bottom, it's signed President Woodrow Wilson, President of the United States, cause these letters patent and seal of the General Land Office to be affixed to the city of Washington the 2nd day of December in the year 1915. So, and it's got Wilson and some other people signed it. And that's it. That's all there is to a land patent, okay? And and they rarely say anything about mineral rights, although they do. In Texas, they a lot of times they'll say it. Out in West Texas, I've got some land patents that reserve mineral rights, but that's all they reserve. They don't say anything about property taxes. They don't say anything about anything else. That Canadian one was in a patent in the box. That means it's color of law. They know it's color of law. They know they stole the land from the Indians. It says the land is granted to John Smith, his heirs, and or assigns forever. All the Crown patents I've seen have always reserved something, mineral rights, trees, water rights, etc. Say nothing about property taxes. It says nothing about easements, says nothing about eminent domain, says nothing about zoning rules and regulations. Sometimes they reserve mineral rights. Other than mineral rights, there are no reservations. I usufruct. The right of enjoying a thing, the property of which is vested in another, to draw from the same all the profit, utility, advantage which it may produce, provided it be without altering the substance of the thing. A usufruct is a type of a trust. Matter of fact, it is a trust. When you pay for land with a banknote, it's not paid for. Okay, you paid for it with an IOU. Think about it. Somebody gives you a Federal Reserve note. They're essentially saying, some guy promised to pay me. When he pays me, I'll pay you. That's exactly what's going on. And so when you pay for the land with that, it's not paid for. Okay? Some guy promised to pay you, and when he pays you, you'll pay him. So it's not paid for. It creates a trust by definition. That's why the government has eminent domain. The government sold the land, and then by paying for the land with their commercial paper, you gave it back to them. That's exactly what you did. Have you ever seen a road that goes along in a straight line, and then when it comes to some guy's land, it turns and goes around the outside of the land to where, and then once it gets around the land, then it just continues on going straight? That's because all those landowners didn't really own the land except the guy whose land that the road went around. That's true. There's Spanish land grants in Arizona. They've been there for hundreds of years. They're still there, and they don't get touched. I know people in Arizona have had land in their family for generations, and they do not pay property taxes and never have. They pass it on from in the family. I've heard of people in Canada who, when they inquire about the land, the response is that the land titles has no jurisdiction. Okay, so it's in Canada too. Federal Reserve notes, Bank of Canada notes, or Bank of England notes, or IOUs, and as found in the Bankster Thieves 1, 2, and 3 videos. And see, there's no such thing as a bank loan video. There is a distinction between when a debt is discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. That's these liars, okay? These bail priests. This is who's done that. This is all the Roman cult. Evidence of the usufruct, okay? They call it real estate. You pay a yearly rent. They can take it away from you. And if they take it away from you, then you do not own it. Your land has easements, utilities, roads. Your land is subject to zoning rules and regulations. If you pay for your land with an IOU, it creates a trust. The way you defeat the trust is you have to pay for the land with gold or silver coin, and you have to say it on the deed. How can you have true loyal title to land? You bring forward all the rights and privileges of the original land patent. You pay for your land with gold or silver coin. At common law, all numbers are spelled out. In other words, it's 5, not the Greek number or Arabic numeral 5. It's Greek or Arabic, I'm not sure which. The number 5 is Arabic, and I'm saying it here, and it's in the matrix. The legal description should be in metes and bounds, okay? In other words, you saw section, township, and range, okay? Now, your land might be just a city lot in some section. So you get someone to come out and do a metes and bounds legal description. They know what you're talking about, and they'll do it for you. I've seen them do it. I've had it done. A patent from the original people would trump any other patent. Yet still, it was difficult to set bounds to ecclesiastical ingenuity. Oh, this is actually a cite from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Okay? And this is very revealing. It goes, yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nominal fiefs. And I'm not sure what that word means. But anyways, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits while the season of the lands remained in the nominal fief, okay, season I'm thinking is possession, who was held by the courts of equity, then under the direction of the clergy, okay, this is in 1835, so the courts of equity were under the control of the clergy, okay, that's true, to be bound in conscience to account to his sesticate use for the rents and emoluments of the estate, okay? And this is the important phrase here. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing, okay? So they're saying, in 1835, they're saying that these ecclesiasts were using a sesticate trust. They were putting the land into a sesticate trust. They would still have it. It would be in the sesticate trust in their dead name. Okay? And the clergy, the courts of equity, was saying that you had to account for the rents and emoluments. Okay? But then they ended all saying that this sesticate trust is the foundation of modern conveyancing. Okay? That's exactly, when they spell that name, when you see that name, that's a sesticate trust. That's ecclesiastical. That's a Roman cult, okay? You have to defeat it. You don't own the land, okay? You can defeat it, okay? But you have to be prepared to go to the wall, okay? What's the price of freedom? What's the price of your land? Is there a price that you're not willing to pay? Because almost everything is done these days with commercial paper. The courts presume that commercial paper was used. You can defeat their presumption by putting on the land transfer document the type of payment that was received, gold or silver coin. And that's the way I always do it. I call it a bill of exchange. Upon receipt of 20 each 1 troy ounce pieces of pure silver each, I do hereby grant and exchange to John Henry, House of Smith, this land with the legal description together with all the rights of the original land patent number, and I put the number in it and I attach it. True copy of which is attached here too, all of which is incorporated herein by reference in its entirety. And then when you get true allodial title, you do not tell them you purchased your land. If you purchased or bought your land, that's a commercial transaction. You tell them you converted some silver or gold to land. Conversion is common law. I've seen court cases that talked about it that way. Some jurisdictions have a land transfer tax or an affidavit of property value. If you pay the tax or provide the affidavit, then you're putting your property in the tax rolls. It's exactly what you're doing, okay? Because how are you doing it, okay? When you do the affidavit of property value, you're telling them you paid it in Federal Reserve notes, okay? If you pay the tax, you're paying the tax in Federal Reserve notes, okay? But actually, that's perfect, because what you do is you make up your instrument and you serve it on them by registered mail. And then they will return it to you saying that it's not recorded, but it's in a special file. Okay? Well, that's perfect. That's the non-tax-paying file. And so that's why you want to do that. And I've done several of them that way. Arizona's good for that. I've heard of places that have a land transfer tax. Matter of fact, they do in Ontario, but I never tried it there when I was there. But I have done it in Arizona on several pieces, and it worked great. Some counties require it to be a land title document before you can record it. So when you're recording documents, sometimes like an affidavit, okay? So then all you do is you put on the top, it's a land title document. It's easy to make any document a land title document by putting at the top right corner on the front page the following information. And this is, remember I was talking about legal descriptions, okay? So you're going back to the meets and bounds legal description. You don't have to go into the northwest quarter or whatever acre in this section, okay? All you need is section, township, and range. This actual legal description's in Alberta. Okay, because in Alberta, they use the 4th meridian as their basin meridian. And so everything is taken from the 4th meridian. Meets and bounds legal description. Meridians are a vertical line on the earth run from pole to pole. Ranges are horizontal lines that define the top and the bottom of a township. A township is 6 miles square, 36 sections. A section is 1 square mile, 640 acres. 1 acre is 43,560 square feet. So an acre can be any shape you want, okay? As long as it comes to 43,560 square feet. It doesn't have to be square. A section probably doesn't have to be square either, as long as it's 640 acres. In older parts of the country, the meets and bounds legal descriptions run from landmarks like the old oak tree or where the rivers meet. Some of them are quite interesting. Meets and bounds legal descriptions are common law. Every state has a basin meridian where all legal descriptions are taken from. Alberta uses the 4th meridian, which is the eastern border. Utah uses the Salt Lake Basin meridian. Arizona uses the Gila and Salt River meridian. Your local city planning department will probably be able to tell you what section your land is in and the basin meridian is taken from. Or if you're in a county, go to the county planning department. An instrument is deemed in law filed at the time it's delivered to the clerk, regardless of whether the instrument is file marked. And so, again, you serve it on them by registered mail. You have proof of service. Whether they send you something back or not, it doesn't matter. You have proof. But usually they send it back and say, well, we can't file this because you haven't paid the fee or you haven't done this affidavit or whatever. But we put it in a special file. Well, that's perfect. That's the non-tax-paying file. The King of England held ownership of land under a different title with far greater powers than any of his subjects, okay? If you're one of the slaves, you really don't own it. Though the people of England had fee simple titles to their land, the king actually owned all the land in England through his allodial title, and though all the land was in the feudal system, none of the fee simple titles were of equal weight and dignity with the king's title. See, again, it was all feudal. Anyways, I know people who have had land patents on their land and they pass them on to their family and have done that for generations, and they do not pay property taxes on it, never have been contacted for any taxes. I currently own land that's not on any tax rolls. A lot of it depends on how corrupt the local officials are, property taxes are theft and a denial of due process. What is due process may be ascertained by an examination of those settled usages and modes of proceedings existing in the common and statute law of England before the immigration of our ancestors. The expressions due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers as it existed and was understood and administered when that instrument was framed and adopted. It is manifest it was not left to the legislative power to exact any process which might be devised. The due process article is a restraint on the legislative as well as the executive and judicial powers of government, and cannot be so construed as to leave Congress free to make any due process of law by its mere will. Due process is nothing to do with the government. It has everything to do with them, but they cannot change it. This video is not intended to scare anyone or make them feel like all is lost, because it absolutely is not. We need to know what the problem is before we can know what a good solution is. So the point is no matter how corrupt your local officials are, never give up. It is never over until you say it's over, okay? It is never, ever, ever over. I know that works in tribulation. I know the blasphemy of them that say they are Jews or Christian or not, but are the synagogue of Satan, okay? These people are Satanists. They're thieves. Everything they do is a lie. That's what that Sesticate Trust is. It's a lie. It's a fraud, okay? Everything they do is a fraud. They are thieves. They are the lowest form of life there is. Ye are of your father the devil, and the lusts of your father you will do. He was a murderer from the beginning, and abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own, for he's a liar and the father of it. That's these people. They're Satanists. They're thieves. Okay? Fraud is lies is Satanism. But the fearful and unbelieving and abominable and murderers and whoremongers and sorcerers and idolaters and all liars shall have their part in the lake which burneth with fire and brimstone, which is the second death. They're going to go to hell. Okay, and we all have to stand up and defend our rights and defend our property, and do it right to the wall, all the way, and otherwise we might not do too well on Judgment Day either. Okay, so I hope that everybody listening to this does well on Judgment Day. By which he also went and preached to the spirits in prison. It shall come to pass in that day the Lord shall punish the host of the high ones that are on high, and the kings of the earth upon the earth, and they shall be gathered together as prisoners are gathered in the pit, and they shall be shut up in the prison, and after many days shall they be visited. Okay, so spirit prison's hell. And these Satanist Baal priests that are in the kangaroo courts, they're all going to hell. Okay, everything they do is a fraud. They're Satanists. It's evil, and they should all be put to death, actually. It behooves every man who values liberty of conscience for himself to resist invasions of it in the case of others, or their case may, by change of circumstances, become his own. If ye love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or arms. Crouch down and lick with the hands which feed you. May your chain set lightly upon you, and may our posterity forget that you are ever our countrymen. Nobody could have said it better than Samuel Adams. When shall it be said in any country of the world, my poor are happy, neither ignorance or distress is to be found among them. My jails are empty of prisoners, my streets of beggars, the aged are not in want, the taxes are not oppressive. The rational world is my friend, because I am friend of its happiness. When these things can be said, then may that country boast of its constitution and government. We have absolutely nothing to boast of here. The prisons are full. We have these Satanist order followers running around populating the prisons. We have the streets are full of beggars. They're stealing people's land all over the place because the people are so ignorant. Ignorance is everywhere. But if the watchmen see the sword come and blow not the trumpet, and the people be not warned of the sword come and take away any person from among them, he is taken away in his iniquity, but his blood will I require at the watchman's hands. This is my effort to make sure that I'm held blameless on Judgment Day, and I hope that everybody listening to this video is also held blameless. Either you're part of the problem or you're part of the solution. You are now a watchman. Circulate this video far and wide. Other videos, Bankster Thieves 1, 2, and 3, Churchianity series, no such thing as a bank loan, bar members 1, 2, and 3, do-it-yourself kangaroo courts, martial laws here, do-it-yourself traffic stop, do-it-yourself free mail, Azel pigs 1, 2, 3, and 4, DPS pigs. Okay, and this is only a few of them. I've got over 230 videos. I encourage you to watch them, and I hope you get something out of them. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. And for all the Satanist order follower revenue officers operating in their private capacity, donations to support this work are appreciated. I prefer gold or silver coin. You can put your privileges and benefits up your rectal orifice. But as an extremely less desirable alternative, I can accept the IOUs, Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars. If you find this useful, then you need to pay it forward. If you don't know what pay it forward means, watch the movie. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo. My YouTube profile is Sovereign Living. And my Facebook community page was deleted. I deleted it myself because of their censorship. And I'm in the process of deleting my private group on Facebook because of their censorship. And I've got a video that I've uploaded that tells you how you can hurt Facebook. And so they make their money off of networks, off of the groups, off of people's associations on the kind of things that they're interested in. And so unfriend everybody, remove yourself from all the groups, and delete your profile after you do all of that. And that'll be what hurts Facebook. Yahoo private group is administrating your public servants, and Google private group is administrating your public servants. I appreciate you taking the time to watch the video. I hope you get something out of it, and bring forward your land patents. Quit feeding the beast, and become truly free. When you have your land, you should be literally king on your land. And I hope you put this into your life and practice it. And I hope you have a great day. And let me know your successes. I want to hear about them. And I'll put them in my blog. I want to hear about them. And so I hope you have a great day. And thanks for watching. Thanks.
Okay, everybody, that's going to do it for me. And I hope y'all got something out of this stuff. I'm not going to go over anything else. I think you guys have enough to work with for now. The next time we come back, we're going to have the board up. We're going to be dealing with paperwork so you can see some of the documents and stuff that we're talking about and see this thing in action. Our trust runs pretty smoothly. It's located and spread across the United States, and everything works just fine for us. It's private. We operate in the private. We live in the private. We do things that way, and it's become a habit for me to function that way. I don't see no reason why anybody else will function any other way. But anyway, I hope you got something out of this broadcast, and don't forget our secure party and creditor package is right over there at www.newdebtelimination.com. If you go over to Tarhaka Debt Elimination, you're able to look at the little video there, and it gives you a breakdown on the numerology that we did on the board for you. And you can put in your email address, and I'll send you my free report. Okay? And until next time, peace. Y'all take it easy.